The answer to many of the questions that employers will ask in relation to annual leave during the pandemic will really boil down to two things. One, the specific wording of the contractual annual leave provisions, and two, whether or not the business has successfully varied those provisions. So in most cases, establishing what staff are entitled to and what contractual changes have been consented to will require an analysis of the specific contractual terms and the content of any variation letter or other document that has been issued to employees. Successful variation letters or agreements are crucial so as to avoid breach of contract claims, which may give rise to either employment tribunal or royal court proceedings. So we would encourage employers to ensure that they give this careful consideration. Unless the terms of the variation specifically state otherwise and are agreed by the employee, variation is likely to last for the duration of the pandemic only. But businesses will need to consider whether a second variation letter is necessary to revert to the original contract once business starts to return to normal. And in the event of legal action brought by employees arising from contractual changes, the relevant court or tribunal will consider the specific facts of the variation and the conduct of the parties. It remains to be seen what, if any, weight will be attributed to the pandemic when assessing whether or not the company acted reasonably in all the circumstances. We certainly cannot say that the pandemic is likely to be a get-out-of-jail-free card.
In Jersey, employees have a statutory right to 2 weeks of leave in each leave year, as well as paid time off work, or a day in lieu, on all public and bank holidays. In Guernsey, holiday entitlement is a matter of contract rather than statute. In the UK, the Working Time Directive, which is EU legislation, and the Working Time Regulations underpin a lot of the current discussion about the correct approach to annual leave issues during the pandemic. Jersey and Guernsey are not bound by these laws, however, and the approach will be different in each island. With many holiday plans cancelled or postponed, some employees may be reluctant to take time off in the first half of this year, particularly if the leave days are paid at a lower rate than the normal wage. This means untaken leave levels could be markedly higher in the latter part of 2020 than would be the norm. This might present a range of operational challenges. Some employers might want to ensure that holidays are taken now, while the business is quiet or closed, rather than when business picks up, which could be later this year potentially. In any case, employers in both Jersey and Guernsey should discuss with their employees any proposals to change policies around leave. Some employers already require leave to be taken at certain times in the year, for example, where a business closes at Christmas. The employer might not have the express right under the employment contract to require employees to take a proportion of their annual leave within a specified timescale. If not, the employer's authority to do so is likely to be derived from a discretion implied under the contract. A key caveat here is that an employer's discretion must be exercised rationally. Employers should therefore consider in advance the business case for making such changes. For example, the business might take into account how many days of annual leave can normally be accommodated in the latter part of the year. It might also consider whether there is likely to be a bottleneck in work in the latter half of 2020 if restrictions are lifted. If so, that might support the reasonableness of the proposals, but the business would need to be prepared to articulate envisaged commercial and operational pressures as part of the discussion with staff about potential variations to their terms. Under the UK Working Time Regulations, an employer can require an employee to take annual leave on certain dates as long as they give twice the number of days' notice as the leave period, such as 2 weeks' notice for 1 week of leave. There is no equivalent rule in Jersey or Guernsey.
While some employers are likely to be encouraging their staff to take their annual leave now whilst the business is quiet, other employers will be experiencing peak demand from their business and reduced staffing levels, and therefore may want to restrict the taking of annual leave. For example, some employers might want to stop their employees from taking any annual leave within the next 3 months. The difficulty is that employees are often entitled to choose their annual leave days, subject to notice either under the handbook or any policy. So again, the employer's authority to either refuse the annual leave or defer the taking of annual leave is likely to be derived from an implied discretion, with the caveat that that discretion is exercised rationally. So employers should consider in advance the business case for making any such decisions, and when considering whether they're making the right decision, they should consider issues such as the terms under their contract, how individual employees have been impacted in terms of their annual leave arrangements, how the COVID-19 pandemic might improve or deteriorate in 2020, and how it is impacted on the business and its operating requirements.
Businesses can prioritise annual leave requests from staff in certain groups. This might include those who are not currently required to work within the business, or those whose circumstances would make it more difficult for them to attend work. Examples of the latter might be those who are more vulnerable due to medical conditions, or parents with childcare requirements. Prioritising annual leave requests is likely to form part of the overarching discretion reserved to the employer to manage the employment relationship. Any such discretion should be exercised reasonably. For example, prioritising requests from employees who are not currently required in the workplace may be appropriate if the business is busy or short-staffed. The business should be fair and consistent in such decisions unless there is a clear business need for different treatment for different staff. There is a risk of discrimination claims and reduced employee morale and goodwill. Bearing in mind the employer's duty of care for employees and health and safety requirements, the employer should also take into account the importance of well-being and employees having a break from their work, even at very busy times.
So first and foremost, there's no legal right to carry over your annual leave entitlement from 1 year of annual leave to another. It may be that there's a right contained within your contract of employment. Now, in our experience, such terms are not usually included in Guernsey and Jersey contracts, but it'll be necessary to check that first. In the event that such a term is not contained in your contract whereby you can carry over your annual leave entitlement, and your employer is unwilling to vary your contract of employment, the consequences are that if you do not take all your annual leave entitlement for this year, then you will lose it. The UK has taken a slightly different approach. The UK has the UK Working Time Regulations, which have recently been amended to allow employees to carry forward up to 4 weeks annual leave that can be taken over the next 2 leave years. And this applies where it's not reasonably practicable for the employee to take some, or in fact all, of their holiday which they're entitled to as a result of COVID-19. Unfortunately, there are no equivalent provisions in either Guernsey or Jersey.
If an employment contract provides that an employee will be paid for untaken leave accrued at year end, then the employer will be obliged to honour that provision or else vary the contract. If this clause does exist, employers will need to consider their policy carefully, as there could be a considerable amount of untaken leave to pay for at the end of the current leave year. We are seeing many employers, at least in the first instance, politely request that employees consider taking all their annual leave by the end of the year so as to avoid this situation, and in most cases, employees seem happy to oblige.
With many holiday plans cancelled or postponed, many employees may be looking to cancel their leave. Unless the contractual arrangement between the parties says otherwise, an employer is not obliged to approve an employee request to cancel annual leave. If the employee wants to take their leave on different dates, they must agree this in the normal way. Employees do not have the right to take their leave whenever they want to. The employer can refuse to cancel leave and may wish to do so where there is a legitimate reason. Employers may be reluctant to agree to cancel leave if they have already taken steps to ensure that work is covered by other staff during that period, particularly if the employee requests to cancel leave at short notice. With travel restrictions now likely to continue at least until July, and possibly much longer, it is possible that employees may be more willing to use their annual leave for on-island holidays. Some employers might want to cancel annual leave days that have already been booked by their staff. This might be because the business provides an essential service and is very busy, or because other staff are not available to work due to shielding, self-isolation or sickness. If the contractual arrangement between the parties doesn't expressly refer to such matters, the employer's authority to do so is likely to be derived from a discretion implied under the contract. An employer needs to manage its operational affairs. A key caveat here is that an employer's discretion must be exercised rationally, so employers should consider in advance the business case for making such changes. In theory, the business can direct employees to change their leave dates, but the employer should take care to protect the well-being of staff at this time. Time off should not be cancelled if this will mean that the employee is prevented from taking their statutory minimum of 2 weeks annual leave.